I'd like to give the floor to Janet Benshoof, who is President of the Global Justice Center in the United States, and she has also been invited by the Subcommittee for Human Rights. Mrs. Benshoof is going to talk about the progress and challenges involved since the adoption of Resolution 1325. Thank you very much for answering the call and for coming here to speak to us today about what the Global Justice Center does. Go ahead, please.
Thank you very much. It's an honor to address this body. The EU is unquestionably the global leader in advancing international law and women's equality. As we sit here today, over 250 Chibok Christian schoolgirls are waking up to their 548th day of dehumanizing sexual degradation by their Boko Haram slave masters. ISIS is expanding its genocidal hell, enslaving Yazidi and Christian girls and women in Iraq and Syria for a lifetime of rape, forced impregnation, forced marriage, and forced conversion. What happened to 1325? Where is the responsibility to protect? Why is this ever again instead of never again? The Security Council passed 1325 and 7 additional resolutions to stop rape and war. It also sought additionally to rectify inequality in peacekeeping and post-conflict as a distinct and separate portion. Progress has been made, but progress has not been made on the central goal. Mass rape of women and girls continues to be the weapon of choice in 1/3 of today's armed conflicts. Is 1325 at fault? No. The reason states and the UN working together for 15 years have failed to stop rape and war is more complicated. The fault of the failure is due to something else, and that is what I want to explain in my remarks. The Security Council's very authority to pass 1325 was grounded in its competency under the UN Charter to stop gross violations of international humanitarian law as a threat to global peace and security. That's where it gets the ability to pass this in the first place. In fact, the Secretary General's first report to the Security Council in 2002, it was unequivocal. 1325, he declared, was to stop rape and war, and in order to do so, states must enforce the Geneva Conventions and Protocol without discrimination against women. The 1325 experience starkly exposes the soft underbelly of the international humanitarian law. It does not work for women and girls at the center of today's war. The historic model of armed conflict for which the Geneva Conventions were designed, it was written for men fighting other men with conventional weapons like guns or explosives, cross-country borders. 90% of the casualties were male combatants treated in military hospitals. This is not the face of war that 1325 addresses. Today's conflicts are largely internal, with non-state groups like ISIS dominating. Targets aren't limited to other soldiers. Rather, women and girls are raped, mutilated, and enslaved as equally effective and cheaper ways to win wars. 90% of today's casualties are civilians, mainly women and children, whose medical care is in civilian hospitals. Even war wounds today are different. Brutal rapes result in traumatic injuries rarely seen outside of conflict, including HIV infection, deadly pregnancies, and I want you to know half of the pregnancies from rape and war are children under 18. Brutal penetration results in genital urinary fistulas, many of which permanently destroy girls' and women's sexual and reproductive functions. The Security Council called on states in the UN in 1325 to stop rape by ensuring global respect for the Geneva Conventions. However, the Geneva Conventions aren't up to this task. They remain mired down in the mud of their patriarchal origins. Think about it. The best way to empower women is to honor their rights. Think about this. Mass rape used as a weapon is not responded to like other unlawful weapons. Women's injuries from rape are not treated with the gravity of other war wounds from conventional weapons. Women raped to death are not counted as battlefield casualties. Crimes in war specific to women are ignored, limiting women's access to justice. 1325 calls for an end to impunity, but for what crimes? Many of the crimes against women in war aren't even currently recognized as crimes because they're viewed through a male lens. The challenge for the global community is not how to fix 1325, but how to fix the Geneva Conventions so that they work for women. Until this is done, no Security Council resolution can stop rape in war. And the Geneva Conventions can be fixed. They were designed to be adaptable. The EU and states can do what the Geneva Conventions already require be done. Ensure that there is no adverse distinction against women in the application of each and every part of the Geneva Conventions. This is not about gender mainstreaming. This is about upholding states' duty to ensure non-discrimination of women under the laws of war, a duty so fundamental that compliance is owed to the global community. I want to give two examples of forms of systemic discrimination against female rape victims under the Geneva Conventions. The Geneva Conventions were drafted in two parts: to alleviate human suffering in war by protecting the victims of war, including soldiers, and second, to regulate the means and methods of warfare, meaning seeing that certain weapons are never used. The central premise of the Geneva Conventions is from the first part, and that is, since 1864, all victims of armed conflict, soldiers, civilians, for these victims, states must ensure that the wounded and sick in armed conflict get all the medical care they need without adverse distinction for women or for people based on other criteria such as race, religion, ethnicity, or nationality. Of course, no medical procedures were specifically mentioned because they evolve every single day. Despite this absolute guarantee, girls and women impregnated by war rape are routinely denied abortions in humanitarian facilities in every war zone. The result is forced pregnancy, forced childbearing, more deaths and injuries from continued pregnancy, and more, not less, human suffering. This is not about reproductive rights. This is not about any right to abortion. This is about the fundamental right of people tortured to get the medical care they need to live life again. There's some good news on the horizon. 2 days ago, the 15-year global study on 1325, endorsed by the Security Council and Secretary General, said that denying abortions for female victims of war rape violates Common Article 3, the additional protocols of the Geneva Conventions, and customary international law, and the Geneva Conventions trump any local abortion war zones. Now, given the male culture of war, it's hard for people to think of abortion as being necessary medical care for war-wounded people. It's even hard to think about children and women as being war-wounded. Until recently, no implementation of 1325 by anyone took account of the fact that women victims in armed conflict have medical care rights under the Geneva Conventions that may not exist for women outside of conflict situations. Their rights are different. Now, there's been enormous progress over the last couple years. The UK, France, the Netherlands, the Security Council in Resolution 2122, and recently the EU have acknowledged that abortions are part of necessary medical care, and that victims of war, their medical care is governed by the Geneva Conventions. The UK has already implemented this policy. DFID, its aid agency, sent out a new policy paper on this to all of their aid grantees and communicated to them that this was now required, that they must provide abortions as part of necessary medical care regardless of national laws. And in fact, the UK has said, denying abortions to women and girls raped in war can constitute an act of inhumane and degrading treatment and torture, a separate violation of Common Article 3. The EU Commission has recently indicated that it will follow or adopt, it has adopted, the UK position. Because the EU is the second largest humanitarian donor in the world, and with member states by far the largest, when this is implemented, this will transform the fate of women and children raped in war. Now, one enormous obstacle to any one country being able to instill this in their humanitarian aid is that the United States continues to put a ban on abortion, even to save the life, on all of its foreign aid, meaning that all U.S. humanitarian aid going to the UN or the ICRC that goes to war zone to help war victims has attached to it a complete ban on abortion. The EU policy and EU grantees will be required to then, if it's implemented correctly, to segregate EU money from the US money that has this virus. Then the EU policy can break this deadly monopoly that the US has imposed on torture victims. Let me give you an example. UNFPA is the multi-sectorial coordinator, including for medical care, for victims of gender-based violence in over 90% of high-risk countries. And this includes Nigeria, Syria, Iraq, Sudan, DRC. In 2014, the United States funded 4.77% of the UNFPA annual budget, whereas the EU and 5 top donor states funded 49.2%. Yet, the UNFPA continues to put the U.S. abortion ban on all of its operations. Following the information that nearly 1/3 of the women and children rescued from the Boko Haram earlier this year were pregnant, UNFPA issued a public statement saying, UNFPA does not promote abortion as a method of family planning, nor does it have any abortion-related interventions in Nigeria. Now, the second area of discrimination I want to address is rape as a weapon of war. The most effective thing the Geneva Convention has accomplished is to stop or deter the use of unlawful weapons. This is because states feel stigmatized by using them, as demonstrated by the global condemnation of Syria's use of chemical weapons. Calling for an end to impunity or prosecuting those who use illegal weapons has never stopped the use of an unlawful weapon of war. The use of mustard gas in World War I was not stopped by prosecuting every soldier that used it. It was stopped because states got together and agreed on a ban on chemical weapons, and it was stigmatized so no states used it in World War II. Rape and chemical weapons are equally prohibited means or methods of warfare under law. The Security Council has repeatedly said that rape is being used as a tactic of war. Both the Security Council and the ICRC have defined exactly what criteria need to be established for rape in war to be considered a tactic or a weapon of war under the Geneva Conventions. Women and girls in Syria suffer from rape used as a weapon of war more than exposure to chemical weapons. But they're treated differently, and this different treatment denies women equal protection of the laws of war. Rape is so deeply embedded in the fabric of war that its use as an illegal weapon is never really even treated like the use of a weapon, to say much less of an unlawful weapon or tactic like chemical weapons, dum-dum bullets, or starvation. Take, for example, the Rwandan genocide. One study showed that 75% of the Tutsi women who were raped, that's over 250,000 was the 75%. They were killed during the rape or as part of the rape. But these deaths from rape, right on the battlefield, direct, were not categorized ever as battlefield casualties or wartime deaths. Instead, they're categorized as indirect, nonviolent deaths. Therefore, these deaths don't count against the baseline that defines armed conflict. Putting the focus on rape-using states will remove the deflection to so-called errant commanders. And there's two signs of progress. One state has taken this position, the UK. In the last year's conclusion to the Global Summit to End Sexual Violence in Armed Conflict, William Hague, the then foreign minister, recognized that rape in war is always a grave breach. But when it's used as a method of warfare, that is an additional grave breach. Second, the Norwegian Labour Party, in its 2013 to 2017 party platform, calls for rape used as a tactic of war to be classified as an unlawful weapon or tactic in the Rome Statute of the Criminal Court, so as it will be prosecuted as an additional and separate avenue of justice for women. Now, next steps for 1325. 1325 consists of two sections, women in war and women post-conflict. There's two different legal regimes at work here, international humanitarian law and a mosaic of state laws and human rights laws. But the entire implementation of 1325 has conflated these legal regimes. State national action plans don't even mention 1325. Don't even mention international humanitarian law. And 1325 wasn't passed on a vacuum. It was passed based on the pre-existing duties of states to respond to heinous crimes, to violations of the laws of war. It was meant to augment these duties of states, not obscure them. Now, the CEDAW committee has made enormous strides forward by making general recommendations in armed conflict and post-conflict situations that clearly differentiate between women's rights in these different legal regimes. That's how the Security Council should require in the future that 1325 and its progeny be implemented. Never before has there been such a high level of state, UN, and EU commitment to stop sexual violence in war and to enforce women's rights under the laws of war. And there now are strong international laws that bulwark this political will. 1325, international humanitarian law, obligations to prevent and punish genocide, the responsibility to protect, and new institutions like the criminal court. I am optimistic, indeed very excited, that 1325 and related resolutions can be powerful tools to save women's lives and shape the future of war and of peace. The EU has the power and the influence to do exactly this. Thank you.